Hi, I'm Phillip Hundl. I'd like to talk to you briefly about general estate planning. I oftentimes have friends and family come up to me and ask me, Phillip, what's the most important estate planning document? That's the document I want. Unfortunately, it's hard to give them one particular answer because there's important estate planning documents for different situations and circumstances. So I normally will advise the client that there's typically four general estate planning documents that are most relevant here in Texas, and those would be principally the will. Everyone has talked about a will, but everyone should have a will, and then a medical power of attorney, and then a financial power of attorney, a HIPAA release form, which is a release form for your medical records, and then also on occasion, I recommend clients wish to have a directive to physicians and family. And I'll go over what each one of those documents does. But the will, I believe everyone's heard of the term will. Your will identifies your beneficiaries of your estate, your children, your family, your surviving spouse, and then determines or decides who will receive and what portion or share of your estate. So you decide in your will who will be your beneficiaries of your estate. Also, in your will, you decide who will be the manager of your estate. In other words, also known in the will as the executor. So you get to appoint your executor and successor executors. Also, a person in their will has the ability to determine or decide who they would like to be the guardians of their children if they have minor children at the time of their death. An individual can decide who they would not like to be the guardian of their children. So there's lots of different choices or desires that a person can make in their will, and those are important. Those can be very important decisions at the time of that person's death. Also, there are other provisions that can be in a will depending on the person's circumstance and stage in life. Testamentary trust or contingent trust in the will in the event that the individual passes away and has minor children or a beneficiary with disabilities. There are also components in a will that can provide for trust, which if the trusts are created in the will, they're called testamentary trust. Moving on to the powers of attorney, I mentioned there's essentially two types of powers of attorney or power of attorney in which the individual designates your agent. One is a financial power of attorney that would allow your agent to take care of certain financial matters for you. And in the statutory form power of attorney in Texas, there's a long laundry list of tasks and duties that the agent can perform for you. And the individual can check the certain duties that they would like the agent to perform. If they want the agent to perform all the duties, there's actually a box at the very bottom that they can check. So that is the financial power of attorney. And the financial power of attorney can be made effective immediately or upon the individual's subsequent disability. The medical power of attorney is just that. It's a power of attorney in which you grant your agent the ability to make medical decisions for you, the individual, if you cannot. So medical and financial power of attorney, two different documents. I mentioned a medical records release form or medical information release form. It's called a HIPAA release. Very important if your loved ones or your agents would like to or need to receive medical records, say the individual's in a hospital and there's important medical records that need to be gotten by the family. This medical release form will allow the family to be able to go and get those records. I know in this day and age, most transfer of medical records is done by a push of a button, but in the event that physically those records need to be picked up, this release form would allow for that. And then finally, the directive to physicians and family. This is a form and a document that the individual now makes an election or instruction to doctors and family of what that individual would like to see happen in the event they are in a terminal condition or an irreversible condition. There are essentially two selections. One is to allow the individual to pass away gently and comfortably, restrained from life-sustaining treatment, or the other one is to maintain those type of life-sustaining treatments as long as possible. So once again, those are the general estate planning documents that I believe everyone should have. And those are documents that can be updated as frequently as the individual would like those documents to be updated. So it's nothing that's written in stone. Additional documents that you may hear from time to time, and we can discuss those and maybe at another time, are trust. Lots of different types of trusts, and so I'd like to talk about those in more detail